Judge, and my thought would also be a payment plan. I don't know. Me and Mr. Stocks and I spoke about that last time. Mr. Stocks, do you think you might be able to make a payment of $50?
Jeffrey Bobbitt, 45367, appearing on behalf of and with Mr. Johnson. Sir, could you tell the judge your name and record, please?
Jonathan Johnson.
Thank you.
Your Honor, today's the date and time set for sentencing in this matter. I have received the PSI. I have reviewed the PSI. You have two corrections, Your Honor.
Go ahead.
One in the number of children. Mr. Johnson just had his sixth child who is present out in the auditorium out there and who is lovely.
Congrats.
And he has a new work at RXO Shipping in Canton.
What do they ship?
Our house, the lady like home.
Okay. Okay. What are you doing there?
I actually want one on the shirts and I was shipping all to the people.
All right. Full time?
Yes. Right
Good.
now we laid off the love on.
Okay. How long?
They said the beginning or middle of February.
How long you been off?
They're off 6 weeks after Christmas.
Oh, you got to get a different job, dude. What are they paying you?
But it's
Oh, you
right
got-
up the street from home. So
What's that?
it's right up the street from home. So
You got transportation issues?
mom got
Yeah. What's wrong with your license?
it suspended since I never had it.
I believe, Your Honor, he may have a DLAD
Hmm.
hearing in the future. I have given him the number of district sick.
All right. Anything before I sentence, gentlemen?
No, Your Honor, we would request that you adopt the recommendations of probation.
Mr. Johnson, nothing to add? All right. I'm going to go along with the recommendations. We put you on probation for 12 months. Items 1 through 12 that were recommendations are now court orders. That includes 8 days on the work program. I assess work program as an alternative to jail. You pick the scheduled day. Fines and costs on the file, $1,500. You bring that much money today? Go downstairs and talk about your options. You also owe us money on another file. Failed to display a valid license from 2025. Looks like that's $650. So make some kind of a global arrangement downstairs to get that paid off. They'll tell you what your options are. Questions? Good luck.
Schedule his work program at the same time, Your Honor.
Yeah, same place, same time.
State off, he has time to complete it.
Get it done. Try to get the days done so when they call you for work, you can go. All right. Good luck.
Thank you, Your Honor.
Counsel, Mr. Stocks, come on up. Counsel, you're appearing for Stocks.
Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of Mr. Stocks. Mr. Stocks, will you state your name for the judge, please?
Thank you. And Teresa, what's your last name? You're muted.
I'm Crowder, and I got my daughter Isabella Collins here. She's the victim too.
All right. Anything either one of you ladies want to tell me before I sentence?
I just want to let Mr. Stocks know that his wife really gets him in messed up situations. First his daughter and then us.
Anything else, ladies?
Really put a mental emotion on us.
This wouldn't have happened if they didn't do what they did. They put themselves in this situation. We didn't do anything to put them in this situation, but they put themselves in this situation.
Okay. All right. Thank you, ladies.
You're welcome.
Counsel,
Yes,
have
Judge.
you and Mr. Stocks had a chance to look at the report and recommendation?
I have, Your Honor, and I shared it with Mr. Stocks and his wife, who he gave me permission to share it with via email. It appears to be factually accurate with regard to the recommendation, Judge. I believe the recommendation is for 12 months probation.
Correct.
I'm asking for 6 months probation. I do believe this was a one-off incident. It's very clear that I don't think Mr. Stocks has any criminal history aside from something from back in 1989, which popped up. This was a familial dispute for which Mr. Stocks was forced to intervene. I would also remind the court that this is a 771.1 deferred sentence agreement. So I think what's appropriate, Judge, would be a 6 months term and come back for review. I have no doubt that Mr. Stocks will comply with any terms and conditions of probation that this court sets.
All right, counsel, you and I have a different definition of criminal history because Mr. Stocks has 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 different files out of our court that he owes money on. Some of these might be civil infractions, but I think some of them are misdemeanors too. Granted, they're not felonies and they're not what most people would consider to be serious stuff. They're all involving animals. So dog at large, unlicensed domestic animals. But the gentleman has a history of not taking care of his business with my building. That's a problem. So deny your request to put it for 6 months. I'll do it for 12. You can always petition the court halfway through if he's been compliant. Anything else?
And Judge, I would just ask, I don't think that batterer's counseling is necessary or warranted, honestly, in this instance. This was not a situation of abuse between domestic partners, as the victim, Teresa Crowder, shared with you. This was really an incident between her and her sister through which Mr. Stocks felt compelled to intervene. So for those reasons, I don't think that that would be warranted as a term and condition of probation.
Well, I got pretty much the whole incident report as part of my pre-sentence investigation report. And there's a gentleman here that's got some anger issues.
Then
So I don't necessarily think we need a 26-week program, but he needs to address this anger shit.
understood, Judge. Then I would just ask perhaps that the order of probation could read anger management within the discretion of the probation department. Oh,
I'll go along with that.
thank you.
I'll go along with that. All right.
Can I say something?
Hang on,
Counsel,
Mr. Stocks. You do absolutely you absolutely have the right to say something on your own behalf at the time of sentencing. And if you want to make a statement, you can. My advice typically is I don't think a statement's necessary at this point, but you have the absolute right to say something if you wish to. So go ahead and take the floor if you would like.
Good afternoon, officer. She broke my wife's nose. She gave her 2 black eyes and there was blood everywhere. That's the only reason I know her hands.
okay, but what I read was there a lot more than holding hands.
That's all I did.
Okay. Anything else? Anything else? All right, I'm going to order 40 hours of community service. Everything you saw is a recommendation. We'll do it for a delayed sentence. So after 12 months, if you do everything you're supposed to, including stay out of trouble, it'll be dismissed. It won't stay on your record as a permanent criminal conviction. Any questions about this file? Counsel?
No, Your Honor, no questions.
Thank you. All right, Mr. Stocks, you owe us $3,816 on all these other files. I don't see that you've ever made a payment on any of them.
Not familiar with it.
So you're telling me somebody else named Fred Allen Stocks has come in here with these 14 files?
It's my nephew's dog.
But it's his charge, and I didn't ask you to talk.
Judge, if I may intervene, there's also, just for what it's worth, Mr. Stocks does suffer with some short-term memory loss, which was also the basis for the no contest plea in our case. So I just wanted the court to be aware. I'm anticipating that his wife, Lisa, is the woman who just spoke out in the courtroom. She often does speak on his behalf, particularly as it pertains to his memory issues. So she might be able to shed more light on that. But I don't want the court to think he's being insincere when he says, I don't know what you're talking about. This has been my experience
Fair
over the
enough.
last several months.
Fair enough. Okay. So, Mr. Stocks, I've got files going back to 2023. I've got 1, 2, 3, 4, 5, 6, 7, 8, 9 different files from 2024. In every one of them, you came in here and can you tell me if any of these were defaulted civil infractions? They're all civil infractions? Yeah. So these are all civil infractions, which technically is just like a speeding ticket. If you get a speeding ticket or any other civil infraction and you don't contact the court, you get in default and you owe money. And you owe $3,800. And we've been scheduling hearings and you're not showing up. We can't help you if you're not here.
Well,
Ma'am, out in the hallway or I'm going to put you in jail for contempt. Contempt of court, $100. You want to pay the $100 or you want to go to jail? I've asked you a question. You can talk now. All right, go downstairs and make arrangements. We'll send your husband down when I'm done with him.
I do have brain damage.
Okay. But you still gotta take care of your tickets. You know, if you come in to see us, 2023, when you get the tickets, if you come in to see us, we put you in contact with prosecutors, they work out deals, but when we don't hear from people, the system just takes off on its own. So how do we resolve these files? How's your health? Hold on, counsel. How's your health? Can you do charity work?
I guess.
Like volunteer at a church or something like that? Counsel, I'm willing to give him a review date if you want to try to work out some kind of plan, because I'll close files out for charity work. But I gotta get these files closed.
Understood, Judge. And my thought would also be a payment plan. I don't know. Mr. Stocks and I spoke about that last time. Mr. Stocks, do you think you might be able to make a payment of $50 a month or $100 a month, something to that effect towards this outstanding balance?
Yes, I can do laundry.
Let me ask you this. If you call in all your markers, can you come up with $1,000?
Yes.
When?
Today, if I have to.
Today? You bring $1,000 today or tomorrow by 3. Tomorrow by 3, and I'll close all those files out. I'll waive $2,800.
Appreciate that. I will pay it.
All right.
And Mr.
Tomorrow by
Stocks,
3.
if you get 800 or 700, please call me, because I'm sure we can work something else out with the court.
No, you can't. No, you can't. This is a one-time deal. If I'm going to discount it that much, I want my money so I can close all these files and be done with them.
Understood, Judge.
Yep. I'll put him on a payment plan and get the full 38. But if he wants this kind of a deal, I gotta close these files tomorrow. All right. On today's file, did I give him fines and costs on today's file? I don't think I got to that yet.
I don't believe so. I haven't heard yet on the misdemeanor sentencing.
Here's what I'm going to do. I'm going to order the restitution, which was $329, and I'm going to order the oversight fees, but I'm not going to put any fines or court costs on it.
Thank you, Judge.
That's a separate file that you can put a payment plan on that one. The $3,800 goes away if you bring us $1,000. We clear? All right. Do you want me to write all that down? Can you write that down? Here, do it right on this. Do it right on that. All right, counsel, I'm sure you were taking notes.
I've got it, Judge.
Okay, so we're going to give him a piece of paper that says the $3,800 is settled for $1,000 between now and 3 p.m. And that today's money, he can set up a payment plan, $50 a month or whatever he can swing.
Understood.
You got it?
How much is today's?
$329.
No, it was because I got oversight fee. No, I'm not charging. I'm not going to charge because we're not going to do a reporting probation. So it's $329. I'm not going to put you on a reporting probation. You stay out of trouble. You get the anger management stuff that satisfies her. So do all the boots on the ground stuff and no new charges. And then you don't have to deal with probation at all. Clear, counsel?
Crystal, Judge.
All right. And stick with her. She'll help you walk through this process. Yes?
Yes.
Yes. Okay. You got her number?
I believe so, yeah.
Okay. All right. Have a nice day.
All right, Mr. Stocks, you can head out. I'm going to give you a call shortly.
Thank you, counsel.
Thanks,
Hammond,
Judge.
what do you got?
What began as a structured hearing quickly turned into a moment where credibility, responsibility, and consequences collided head on. This was not a young defendant standing at the beginning of life. This was an adult with history, not just one file, not just one issue, but a pattern stretching across years. The court was not looking at a single mistake. It was looking at accumulated decisions. From the start, the judge made it clear. This case wasn't only about the incident that brought everyone into the courtroom that day. It was about everything that followed and everything that had been ignored. The defendant tried to frame the situation as isolated. A family dispute, a misunderstanding, a moment that spiraled out of control. And while the judge acknowledged the emotional nature of the conflict, that acknowledgement did not erase accountability. The judge had read the reports, the judge had reviewed the file, and the judge knew this case didn't exist in a vacuum. One of the most telling moments came when the discussion shifted from the current charge to the defendant's outstanding obligations, multiple files, unresolved fines, missed hearings, a long record of matters left hanging. This wasn't about violence alone, it was about avoidance, and that's when the tone changed. The courtroom went quiet when the judge laid out the numbers, not as an accusation but as a fact. Thousands of dollars owed, years of unresolved infractions, and no clear effort to deal with them until the consequences became unavoidable. The defendant's response wasn't defiant, it was confused. Claims of memory issues, uncertainty about prior cases, a lack of awareness that, to the court, sounded less like innocence and more like disengagement. That distinction matters. Judges don't expect perfection, but they do expect participation. This case demonstrated a critical principle of the justice system. The court can work with people who engage, but it cannot chase people who disappear. What followed was one of the most striking moments of the hearing. Instead of escalating punishment, the judge made an unexpected move. A deal was placed on the table, not as a favor, but as a test. A significant reduction in outstanding financial obligations, a narrow window of time, a clear ultimatum, pay a fraction now, or face the full weight later. This wasn't leniency, this was leverage. The judge was effectively saying, I will meet you halfway, but you have to move first. And in that moment, the courtroom wasn't about punishment anymore. It was about choice. The defendant had two paths. One led to closure, painful, but manageable. The other led to escalation, enforcement, and consequences that would follow him indefinitely. What made this case so compelling wasn't anger or theatrics. It was the quiet seriousness of the judge's authority. There was no shouting, no insults, just a firm reminder that the court's patience has limits. The judge also addressed the underlying behavior, not just legally, but personally. Anger management wasn't ordered as punishment. It was ordered because the judge believed unresolved anger was fueling repeated bad decisions. That insight matters, because courts don't order treatment unless they believe behavior will repeat without it. This case also highlighted something many viewers miss. The justice system keeps score over time. Each ignored ticket, each missed court date, each unpaid fine. None of it disappears. It waits. And when the moment comes, it all arrives at once. By the end of the hearing, the defendant wasn't walking out free and clear. He was walking out under conditions, strict ones, clear deadlines, clear expectations, and zero ambiguity about what would happen if those expectations weren't met. The judge made it clear that today's restraint should not be mistaken for weakness. The system had offered a way out, not because the defendant deserved it, but because the court was willing to test whether responsibility was still possible. That's the real tension of Case 3. Not whether the defendant would be punished, but whether he would finally respond. This hearing stands as a warning to anyone who believes small issues can be ignored indefinitely. They can't. The system is slow, but it is thorough. And when attention finally arrives, it brings everything with it. Case 3 reminds us that accountability isn't always loud. Sometimes it's quiet, deliberate, and far more intimidating. Because when a judge gives you one narrow door instead of slamming all of them shut, the pressure to walk through it is enormous. The court drew a line. It offered a solution, and it made one thing unmistakably clear. There will not be another conversation like this. The next time this file comes up, the tone will be different, the options will be fewer, and the consequences will no longer be negotiable. That's not a threat. That's how the system works.